came in, I was really pleased to see the quality of those, very diverse, but I think it was very reflective of all the things that we've talked about over the last few months. So now the challenge is to really see if we can reach out and capture at least a 2/3 majority on these recommendations. So Keystone's obviously going to help facilitate us through that process to try to identify those that hold the greatest potential for things that we can either adopt as is or perhaps refine and further develop. I would encourage all of us to really keep our track record of collaboration. Let's listen and also continue our track record of being respectful. And I'm very confident that the whole task force will do that. We do have to be mindful of the remaining time that we do have together. We are coming down to the 11th hour as a task force with really these 2 days plus one additional day that's remaining. So, I would say my objective is I want to work really, really hard today and tomorrow to try to find things upon which we agree to try to get to a yes. And we've talked a little bit about what success looks like. I think we've got a really good framework to produce a set of recommendations for which we can all be proud. And I certainly hope everybody shares that intent and objective. So again, want to thank all of you for being here, for taking time out of your busy normal schedules for this significant effort. And I'm certainly looking forward to hopefully creating a successful outcome. So again, thanks, and I look forward to the next couple of days. With that, Gwen.
Thank you, Randy. I'm Gwen Lackle. I'm a La Plata County Commissioner and one of the co-chairs with Randy of the Governor's Oil and Gas Task Force. I have to say I just completely concur with Randy, although I'm not much of a sports fan, but I do agree. Let's not do the interception in the last couple of seconds of the game here. Want to thank everybody for all of your work in putting together the recommendations. It was a lot of work to read through all 56 recommendations, but I really appreciate the work that went into them. Just a few additional thoughts after Randy's comments, and I did state this in Greeley a few weeks ago. I guess it's just a little over 2 weeks ago. All told, we've been meeting for just over 4 months now. And I think we've learned a lot from the panel presentations, and we've received mountains of public comments. In fact, we've received so many public comments in this last round since the last meeting that we have to look at them on our computers. It was just too much to print. All told, as I said, the task force members submitted 56 recommendations to address conflicts with oil and gas development in Colorado. But I'd like to just take a minute to step back. And I know this has been a really highly politicized task force, but I would really like to take a step back and look at the executive order and what we are. We are an advisory body. We do not have decision-making authority. We are here to make recommendations to the legislature and to the oil and gas regulatory agencies in Colorado. And I just want to really stress, let's make these strong recommendations for the people of Colorado. And the people of Colorado really deserve the commitment of the governor and the legislature and the oil and gas regulatory agencies to enact the best possible protections for the people of Colorado. And Matt Sura recently sent around a communication. I just want to beg, borrow, and steal one of the things that you put in your memo to the task force, that we have the opportunity and the responsibility to suggest a better way for Colorado. So with that, I really look forward to the discussions and really urge this task force to consider very strong recommendations to the legislature and to the oil and gas regulatory agencies. Thank you.
With that, we'll just do our regular business items of, we're going to come back to housekeeping, just reviewing our antitrust statement. Again, the task force has a number of organizations and entities that are potential competitors with each other. So we just want to remind the task force that we intend to fully comply with both the letter and spirit of the antitrust laws at the state and federal level. So if at any point you all feel that we're venturing into territory that may violate those laws, please let the chairs or the facilitators know, and we'll immediately cease conversation along those lines and move forward. I'm not going to read the statement verbatim. You've all seen it multiple times, but again, things with respect to prices, terms of sale, discounts, other things that could impact prices, bid rigging, boycotts, et cetera. So again, just a reminder and again, a nod from you all that we will be complying with this. With that, then I'd like to turn it over to, well, actually, I think, Lisa, I'm going to have you on hold because I know we have a little bit to discuss with that. We will review the agenda real quickly for today. Of course, I just nudged it, love it. All right, it'll come back in just a second. There we go. We have some minor changes to the minutes to suggest before we approve those. We then would like to, we have some housekeeping items from DNR, and we know we've had some questions from the governor's letter that went out on Friday. So we'd like to have a chance to review those and review just the package of recommendations that you all submitted and the polling that we went through and how we're going to use that to structure our conversation for the next few days. So really our agenda for the next few days is to get through those recommendations and get greater clarity from you all, since this has been the first time many of you have seen those, an opportunity to answer questions, get clarity, see where there's some potential areas for both consensus or meeting that 2/3 majority, as well as if there's any places we can combine some of these ideas together to move them forward for a greater sense of consensus going forward. So we'll go through the specifics of how we're going to do that. But today we're going to spend most of our time on the recommendations that fell into sort of that middle category of needing further having some support, but needing further conversation. And those topic areas really are around the topics we've been discussing for the past several meetings. So we'll show those to you in just a bit. And then tomorrow we'll get into the conversation of those that received a majority of support in the green area already. And so thinking that those don't need quite as much conversation, but we'll have an opportunity to review those as well. And there were quite a few of those, actually, is the good news. And then those that did not receive as much support, that got a majority of red selections in the polling, we'll have time to go through tomorrow. And then we should have some time to revisit anything that came out of the conversations today, any revisions that people want to suggest. So that is really our agenda for the next 2 days. Before we get into the minutes and everything else, it probably does make sense to go around the table and let people who are listening remotely know who's here. And I think you all know each other by now, but just so those in the audience know who's around the table.
Christine Scanlon with the Keystone Center, helping to facilitate.
Hi again, this is Gwen Lackle, Plata County Commissioner.
Russ George, member of the commission.
Jim Fitzgerald, member of the commission.
Bernie Busher.
Jeff Robbins.
Sarah Barwinski.
Will Tour. Steve Moreno.
Pat Quinn. Lem Smith. I'm sitting in for Peter D. Today and tomorrow and at the end of this month.
Matt Serra.
Perry Pierce.
Good morning, Brad Holly.
Kent Pepler.
Good morning, Albert Wedgeworth.
Bruce Rowe.
John Golden Dubois.
Becky Corliss.
Dan Kelly.
Scott Woodall.
And Randy Cleveland.
Thank you. With that, we'll go ahead and move into just the approval of the minutes from the last meeting. They were a little more detailed last time because there was a lot of rich discussion that took place. We had 2 minor edits that we'd like to review with you on page 6. We just wanted to there was a clarification that we're not actually talking recommendations yet. So in our conversation with Mr. Lepore, just changing the word from recommendation to discussion to support his 22 FTE suggestion. So that's the first change. And then the second change relates to the conversation we had about voting, which we'll talk a little bit more in detail today on the second day, just to better reflect where we are today, which is to strike the more detailed language, but that we discussed with Mike King, how we are going to move forward with our recommendations, which we'll discuss in a moment here as well. So those were the 2 suggestions. I'm sure you all had time to read the lengthy meeting summary in addition to all the recommendations, but if those, I would suggest we look for a motion to approve these with those changes if there are no objections. Okay. Thank you, Ms. Wedgeworth, and Mr. Moreno seconded. Any discussion before we move to approve? Can I take a vote? Yeah, you want to take a vote?
All in favor, say aye. Aye. Any opposed?
Thank you. All right. With that, then we will get into housekeeping from DNR. Lisa has some general announcements, and then we can also review any questions from the governor's letter. Lisa.
Good morning, Task Force. Just have a couple of quick things. We will be meeting in this same location for our next and final meeting. We'll also be here tomorrow, obviously. We're meeting at the end of the month for 1 day only on the 24th. We'll figure out the timing for that meeting when it gets closer, but plan on an all-day meeting, and we'll be here at the convention center. I don't know if we'll be in the same room, but we'll be here on site. Some of the out-of-town folks may still want a hotel room for the night before or the night after or both, since it'll be all day, and we'll reserve the same space, which is the Embassy Suites right across the street. So as always, let us know with plenty of advance notice because they do drop rooms. We book a block of them. This month, we sent you a link to public comments since there were so many comments. We had 900 pages, and the idea of printing 900 pages 21 times didn't seem worthwhile. If anybody does want those comments in hard copy, we're happy to do that. Just let us know. Otherwise, we sent you a link, and we'll likely do the same thing for next month. I also just wanted to quickly reassure this committee that we have not and will not reveal contact information for any of you. It has been a constant request for that. We've had dozens of requests for that information, and we always say no. So whatever kinds of communications you have received recently, I'm not sure how that information was revealed, but it did not come from DNR, it did not come from Keystone. So in the age of Google, it might not be all that hard to piece together for an enterprising person wishing to reach you. And I think Mike's here to answer questions if you have any about the governor's letter.
I was just kind of a little bit taken aback by it. And so can you kind of explain, Mike, exactly, based on the executive order and the governor's correspondence, what he is expecting to do or what's been laid out for us to do from the very beginning?
Thank you. The discussion ensued in Greeley, and it became apparent that there were multiple ways that you could read the executive order, and different people were reading it differently. My attempt to clarify what I thought the executive order intended to do muddied things, and for that I'm profoundly sorry. But it became apparent that we would spend hours this morning debating what the charge was, what the product was supposed to be if the governor didn't clarify. We sat down and he said it was his intent and Congressman Polis's intent from the very beginning that all recommendations, regardless of tool of implementation, be a 2/3 majority to move forward as a formal recommendation of the task force. That is what the governor's charge is, and that is what that letter is intended to convey.
Are there any other questions or comments for the DNR staff? Becky Corliss.
I have a question, if I may, about timing. I read the letter to suggest that the time frame holds as is, that he expects a report from us by the end of the month. Is that right?
That is the current direction to the task force. That's
Okay.
correct.
Any other questions or comments for staff? Okay, thank you very much.
All right, we're going to move into what will be the bulk of today, which is to work through those recommendations that via the survey results showed the greatest interest in having further discussion, that folks have would like both to clarify some intent and to ask potential questions as to an author's openness to changes to the proposal, et cetera. So
And actually, before we do that, there was an updated chart that was handed out to you this morning that has some blue bars across it. So no surprise, as you read through them, there were a couple that were strikingly similar. And so we worked with the authors of those to combine those proposals. So that's reflected in your chart because we know you all took notes, and based on the originals, we won't completely strike out those numbers so that you can comment on those as a package, but just know that the authors of those, where there's a blue strikeout and then both names are captured in the cell above, did agree to combine their proposals so that we could winnow down the list just from a housekeeping perspective of those that were really from an intent standpoint, 100% the same. Also handed out this morning was a revision that Ms. Lackelt and Mr. Busher worked on to combine the two ombudsman's proposals that were before you. So that now takes the place of number 55, and that was a single page handout in front of you. So just so you're clear on what we're talking from and what that looks like going forward. And you all probably made notes to combine the ones that were combined that were fairly apparent.
Thank you, Sarah. So we've loosely grouped these in more of an effort to have some parameters around the conversation, so we're not talking about all 25 at one given time, but we will work through this list in the order that you see up here on the screen. There were a lot, as you might imagine, who had very similar results. If they fell into the yellow, which was a category of needing further discussion, or green, supportive, those combined totals were very close to one another, so we've worked from that perspective. We want to move into. So here's how we're going to at least manage the time, and I want to acknowledge right up front that we don't have enough time to give all of these their due in the way that I know that you would like, but given that we have today and tomorrow to really come forward with what we feel will be a much needed focus for final recommendations, we're going to have to put some fairly strict time limits on our conversation today. So we will work through each of the proposals. We will ask the author to share with our group the intent of their recommendation, and then have just a couple of initial minutes of clarifying questions for folks to have a better understanding. We'll get through the first group. So for this morning's discussion, that's 8 that we will work through at one time. 9? It is 9 at one time. And then we will open it up to full group discussion of all 9. And that's an opportunity for you to weigh in with your thinking on any particular recommendation. You can ask the author if they would be open to suggestions, to changes, any input that might be helpful in better clarifying your own position on any particular recommendation and giving insight to the author on your feedback. At the end of that, we will come back. So this morning we'll work through the first group. We'd like to use the lunch hour as an opportunity. The local government questions are the ones that have the most substance, frankly, behind them largely, not entirely, but largely. So we'd like to use the lunch hour as an opportunity for folks who are vetting these proposals to talk with the author, to find out if there's places for potential consolidation, if there's someone who even would want to withdraw their proposal in support of another, for example, or be open to amendments or changes to that proposal, which are substantive in nature and might change a person's ultimate support or not for the recommendation. So we want to give you all a little bit of that informal time as well. Okay. So here's how we're going to work with our straw polling. At the end of the discussion, by each topic area, you can see you have cards in front of you. Today we are using the red, yellow, green cards. Once we get to that place, we'll reiterate what those mean. Before we take a vote, if you will, through the polling, we will revisit with the authors any changes that they'd like to suggest for consideration to their proposal prior to folks weighing in with their support or not. Red is obviously, I don't feel like this is going to be a proposal that we should continue to consider. Yellow is, I am leaning towards supporting this proposal, but need to see some changes. And green is, yes, I support this. Tomorrow, just be aware in the back of your mind, we will revisit every proposal you see on that list and go back through, and we're going to ask for red and greens because we have to get moving forward with where the focus of this group is. What we're looking for is a 50% threshold in order to move to final discussion. So it has to be 50% green tomorrow, or it will not be considered as part of any kind of final consideration for our final, when we do real roll call voting. People have asked about the majority and minority report that the governor has expressed an interest in receiving. For those recommendations that pass that 50% green threshold tomorrow, that will automatically at least gain a spot in a minority report. Obviously, the majority report will hit the 2/3 number that Mike King just referenced. So there will be an opportunity for those fully developed proposals, which will be ultimately voted on at the last meeting to then be reviewed by the governor. So just to let folks know that. I know that's kind of a lot of information. Any clarifying questions needed? And we'll revisit this as we go along. We certainly will revisit it before we do the straw polling. Yes, Rebecca Corliss.
The direction to us is that the voting today and tomorrow is for purposes of keeping things under discussion.
Yes.
It's not a final vote as to what ends up in the
We will not be taking a
recommendations.
final vote. No
Understood.
formal votes today, just the straw polling through red, yellow, green, or red and green. But what it does do, it allows the author of these recommendations to see where the group is, to work, if you can see where people are weighing in and what kind of changes you may need to make to your recommendation in order to hit that 2/3 threshold, you can start to understand better the input from the group and consider whether or not you want to make those changes. So there will be some hard lines, which are a little bit difficult, but I think at this point, it's where we are in terms of our own vetting process. Okay. Sure, I'll let you do that.
Okay, and it's probably easier, actually, the handout with the bar graphs in front of you shows you the results of the polling that we did, but just so, since these have no names attached to them, it's a lot of numbers, it's hard to digest, but again, as Christine said, what's on our agenda for the day today are the ones that received, were not a majority red or a majority green, but we're somewhere in the middle needing more discussion. So between the yellows and greens, there's a fair amount of support for them, but also a need to have further conversation. And we've grouped them loosely into some topic areas because our sense is many of those might be, you may see some opportunities to combine proposals, or we may have some competing proposals that we actually need to pull on in terms of where the preference of the group is to move forward. So these are the ones we're going to get through today. And again, we'll be showing these to you as we go. So you don't have to write this down right now. We'll have up the groupings as we go forward. Yes. Oh, so the first number after the parentheses is the red, and then it's yellow and then green. So you're right. The colors are a little hard to interpret there. So
we're not going to get through the full list today? Is that?
That's correct. So we're going to get through all the ones that really require further conversation today. Tomorrow, we will take up the ones that got a 50% at least of green support. So we'll take those in a little more rapid fashion tomorrow, is our thinking, that we'll get through those more quickly. And then the reds, and then we'll come back to this list after we get through the reds and greens tomorrow. Mr. Tour?
So just one concern about that approach is that some of the recommendations that we'll be talking about today are, I think, intimately connected to some that we have set for tomorrow. So for instance, some of them are inconsistent with each other.
Right.
And so it seems to me that there needs to be at least some ability to reference that in the discussion today.
Yeah. So our thought is to, as Christine said, give an overview of the ones that are that are clearly in this bucket by topic area, and then we will have time for full group discussion of them as a whole. So if you want to bring in some of the other ones that fit in the other categories during that conversation, that you're welcome to do that. Actually, as groupings, it actually turned out pretty well in terms of general concepts. We need to talk more about local government authority. I'm sure that's no surprise, and how that, and multi-well sites. The COGCC staffing was less controversial, for example. So those may end up going together as a package in terms of what kind of staffing support you want to provide, given how those others come out. Again, another reason to put those less controversial ones towards the end, because they're more, they tend actually to be more implementing kinds of recommendations, whereas the big picture policy recommendations are really the ones that need further discussion today, if that makes sense. Mr. Hawley.
Yeah, thank you. Just a clarification. So my understanding is everything that's less than 50% green we're looking at today.
Except for those that got more than 50% red, and then we'll take those tomorrow. And those are not very many, actually.
So we will re-vote today on these.
Yes.
The new vote will replace what is currently on the board.
Correct.
And if it goes above 50% green, it moves on to tomorrow.
Correct.
And if it does not today, if it stays at 48% or whatever, then it does not move forward. Is that correct? Okay.
Okay.
And just to, we do have one alternate here with Lim Smith. Lim is able to participate in the straw polling per the executive order. The only place that is restricted is for formal voting on the roll call votes we'll do at the last meeting. He will not be able to participate in those. Anyone who is absent from that meeting will be subject to the rules that the co-chairs outlined in terms of electronic voting.
Are there any other questions or clarification needed from the task force members? I just want to make sure that everybody's clear on the process and okay with the process before we move forward, because I think in the end, things can get muddy, and if you have any questions, please ask questions. Mr. Quinn.
Could you go back to that slide that showed the 50% green? So if you don't have 50% green today, we're not going to discuss it today?
We'll discuss it tomorrow.
We'll discuss it tomorrow. Because I drafted mine in such a way I didn't anticipate any green. Because I was so specific. I was so specific on what I proposed. So
we'll talk about yours today. So that will be on the agenda for today.
Okay, because it's got like 80-some% that want to look at it. So, the green, the goal wasn't to draft for green, the goal was to draft for.
Yes.
So we will discuss mine today?
Yes.
Okay, I don't want my feelings hurt.
Mr. Hawley has his card up.
Can you show the
And then
list of
Mr. Rao.
50% or higher reds? I saw it flash up briefly, but not. So our plan is not to discuss these 4 proposals, is that correct?
And again, these are, so these were the 4 that did not receive 50% yellow or green. But again, they are, as was noted, related to some of the things that we'll be talking today. So my guess is the authors may make a sales pitch to get them included to some of the other proposals today if they feel willing. So 15 and 16 relate to multi-well sites, 34 relates to the public health studies, and then 47 relates to a rights of way issue, which again is sort of one of those implementation issues which the group may want to revisit depending on how the others come up. But that's today. So those 4 we'll discuss after we go through the greens. Mr. Rao.
Thank you. I think your description was very clear, but I think it would actually be helpful if we're all going to manage ourselves to the set of rules, if we had a written copy of the rules we're following, because I'm sure there will come a time where we'll have a disagreement about what the rules were that we agreed to. So I think it'd be a really good idea if we all had sort of plastered to our forehead a copy of the rules that we're following and the game that we're playing. So.
Okay, we'll get those for you by lunch. To hand out.
Any other questions? Mr. Moreno?
Just one more time. I know we've said it a couple of times, but just so we're very clear on these 4, if there's not over 50% in agreement to move it forward to discussion tomorrow, it completely is off discussion for tomorrow. Is that correct?
No.
Go ahead.
We are not discussing those today. All of the greens and the reds will be discussed with minimal time tomorrow because that's what we assured folks, that we were not trying through that survey to take anything off the table. We will move tomorrow to red and green polling though. And we will move through all of these, including the reds, if you will, to get a final poll. So we know what does not progress to the next step, which is for final proposal consideration.
Thank you.
Okay. Okay.
So, and again, so you can think in terms of categories, which is easier than numbers likely. For the agenda today, we hope to get through the majority of the ones on local government authority. And again, I think there was only one of these that ended up in the green category for tomorrow. Multi-well sites, again, we saw a couple of those that went to red. The comprehensive planning proposals, air and water, there were, and disclosure of chemical usage, sort of lumped together. Again, those may or may not be completely lumpable, but we'll take those up. And then some miscellaneous ones that also pass through. So again, if we start to take them in these groups, hopefully it's not quite so overwhelming. We will, for the local government authority, our hope is to get through both the presentation of those issues. And we can, I see you all taking pictures. If it's easier for us to email this out to you, we can also email it to you so you can have a copy of it. We will, our intent is to get through the presentation, most of the discussion before lunch on local government. As Christine said, we'll come back to take the straw polling after lunch. So again, if there's any huddling that needs to occur, and we can get very, very clear on the procedure for that and answer any questions as we get into the substance and go through and do the straw polling after lunch. And then our hope is to go through the others. You'll see that the numbers of proposals for the rest of them are fewer. And so those should go a little bit more quickly, is our hope. So we'll see how we go. If all goes according to the way we've planned this out, we may have a little bit of time before 5:30. Again, if we need to have some informal groups get together to discuss joint proposals, combining anything before we adjourn. So we hope to provide some time for that this afternoon, time willing. Okay.
All right, are we ready to get moving? What I'll do is, again, this is just a first lightning round, if you will, where the proposal is introduced by the author. Clarifying questions are open to the task force, and then hold the discussion of that until we get through all 9, and then we'll have a full discussion and vetting of all 9 where you can express both opinion and suggestions. So no pressure, but our first person up is Mr. Woodall. And Sarah will be doing some timing, so if we do have to cut you off, again, it's just a matter of trying to manage to get through all these in the best way possible.
Well, I doubt that I have a 7-minute preparation of a presentation, so I don't think this will go 7 minutes. So we might be off the clock here for a, maybe, I'm sure we'll be off the clock here pretty shortly. What the proposal that is written here is to put the oil and gas development into the commercial mineral deposit term. And what that would be, I think that fits in with gravel, it fits in with a lot of the other minerals that various local governments have zoning and control over, and it's assigning that same label to oil and gas development. I think it's pretty simple, it's pretty straightforward, and it's just kind of another way of saying that we do have the right to protect those minerals that we are developing that are below the surface. Very similar to any of the other minerals that the local governments currently zone and have authority over.
Thank you. Clarifying questions from the task force? Mr. Butcher?
I have a question. I haven't been able to pull it up yet, but does this require the oil and gas industry to go through the local planning process? I read the entire statute, not just where this change is being made, and was frankly confused as to the ultimate way it would be interpreted and the effect of the proposal. Can you enlighten that?
Yeah, and I think the answer to that is no, it would not.
Becky, do you have a follow-on, Bernie, or you want to mull that a moment?
I'm going to need a few minutes.
Okay, and we also, by the way, we do have obviously DNR and COGGC staff here. If there's a question, you have them to help in your understanding as well. Rebecca Corliss.
So am I correct in understanding this to be a proposal that would require local land use planning to allow access to such a deposit when they're going through their land use planning process?
That is absolutely correct. So that is, I think part of the intent is it would fall into the master planning and it would lend itself underneath that.
And I should know the answer to this because I've been through a little bit of it on the coal side, but how do the local land use planners get information about where the commercial deposits are? Because clearly there's not going to be as much oil and gas in some parts of Moffat County as there are in Rio Blanco. So how does that information get transmitted?
I'm not sure if I have the direct answer for that, but clearly there has to be an obligation for that information to be made available to the local planners. So it seems like there's got to be something that comes forward from industry that would say, this is perspective or there's development or something there.
Okay, so one last follow-up question, if I may, and that is that it seems to me it's a lot cleaner and easier to figure out how you need to reserve access for coal or sand or gravel or limestone, because at least at present, you have to go vertical to get to it. It seems to be a little more complicated to figure out how that would play when the concept of horizontal drilling comes into the picture.
Can be, but I think it's trying to recognize that it is in that same category that you have to provide access. And so it's access, vertical access, horizontal access, or technology that is yet to be developed. I think it's just putting the label on it that you have to be able to have access.
Okay, thank you.
Okay, I'm going to move us on. Will, followed by Matt. Will Tour, followed by Matt. Okay, Pat Quinn. You were, I'm sorry. I had Gwen and I are together facilitating. We lost track of people. I'm going with Matt Sura, and then I had Jeff Robbins, and then Pat, if you don't mind going then. Matt?
Thank you. Scott, I had a similar read of this as
Bernie did, given that it is located in kind of mining regulations. And my understanding is that the Mineland Reclamation Board, Mineland Reclamation statutes require local government approval before mine can move forward. And without coupling, your recommendation with a similar local government approval requirement, I think that we're likely to run into some real problems, with that local governments feeling like their hands are tied even more than they are today.
Yeah, I don't know if that was a question or an opportunity for me to comment.
Please.
But yeah, I'll comment. I think what this is putting the terminology that applies to the coal and the gravel to this, and that's what's in this recommendation. Clearly, I think your imitation of coupling it with some other things about how then you grant that access and how you go about the approval of that access is probably a coupling mechanism.
Okay, I'm going to move on to Jeff Robbins.
Scott, this is Jeff Robbins for the folks listening in the air. A couple of questions or comments. This statute was done in 1973, I believe, and I believe it was done in a manner to encourage zoning by communities because we didn't have a lot of zoning back then. Later in this statute, it speaks to the fact that any identified commercial mineral deposit is going to be subject to any pre-existing zoning that existed at a local community. Is it your point that a newly identified in a local plan or master plan, a newly identified mineral resource would be subject to pre-existing zoning?
I'm not sure I thought through all of that to answer that as a yes or a no question. So I'd have to think through that one.
Okay, and I'm going to finish with Pat Quinn.
And maybe people touch upon this. I'm reading the last, and once again, I'm not a lawyer or even want to pretend to be one. Where we say down here that in a manner, in the very last sentence, in a manner which would interfere, that you can't interfere, the local government can't interfere with the present or future extraction of such deposit by an extractor. So, I mean, it would, so the goal is stated explicitly that the goal within a local government would be to extract this mineral, and you can't interfere with the extraction of that. I mean, that becomes the supremacy we're talking about. I mean, there were some proposals that people were talking about balancing out, balancing the COGCC charge, where it's, where the extraction isn't necessarily the number one goal. I mean, it's what's the word the governor uses? Harmonize. And my concern about this one is that it wouldn't necessarily work towards harmonization, if I'm reading this right.
I think it comes back to, and it probably is a coupling issue that we touched on just a few minutes ago. What this is saying that it is a resource that is protected, that is going to be developed.
Right.
It's going to be developed, and I think that's what we're trying to say, that it's going to be developed. Now, we talk about how we grant that access, how you locate wells, how you harmonize, all of those things, I think, is a subsequent part of this. This is just saying that it is a resource that, will be developed.
Okay, I'm going to move us on. I'd like to remind folks, clarifying questions, since this is a lightning round, very short overview, and we will allow for a full discussion where you can really have much more of the back and forth dialogue, where you can state opinion or concerns and those sort of things. We're going to move to Jeff Robbins.
Is that to discuss number 2?
No, number 2, yes. Sorry.
Okay, so this is recommendation number 2, which
Yes.
is my recommendation. Again, I don't know that it is, requires a great amount of additional specification. It was an attempt to provide for some of that harmonization at the state regulatory agency. For the commission members, task force members, the state commission has in the recent past gotten more involved in some of the surface or land use issues that local governments have traditionally been involved in. My idea was that provided a local's regulation does not result in preemption or an operational conflict, it should be allowed to go further than the state in certain areas. And that's really what this is. It would be an express recognition by the state COGCC of that point.
Clarifying questions for Mr. Robbins on recommendation number 2. Pat Quinn, is your card up just as a lingering card? Okay.
No.
Rebecca Corliss?
Jeff, could you speak a little bit to operational conflict and what that is, how it would be defined? And I think that also dovetails into another one of your recommendations, doesn't it?
Yes, it does. One of my other recommendations is to alter or to better define operational conflict. I'm currently, and I don't want to be lawyerly here, but currently, when a local government uses its regulation in a manner that a court finds is impeding the state's interests, then that local regulation can be deemed to be invalid, and so it's sort of stricken out. This rule recognizes the current standard and does not try to change the current standard. Instead, it just establishes that given today's operational techniques, a local government's land use rules that do not impede development of the resource, but that are stricter than the state, should be considered valid.
Other questions for Mr. Robbins regarding proposal number 2? Brad Hawley, please.
Sorry, Mr. Robbins, I can't see you, but I can see the screen. Just a question, and I think you spoke about this, but I'm not sure I got it. Do you see this as defeating the preemption of the state, and does this give a local veto?
No.
Thank you, Mr. Tour. Oh, and okay, Mr. Tour followed by Perry Pierce.
Jeff, could you give a couple of examples of the types of rules that under the current system might get struck down by the state that could go through under this recommendation?
Well, the state has standards concerning addressing noise and things of that sort. They have standards concerning visual mitigation. Those are the things that I think that, given today's operational techniques, the local community may want to go further in addressing those sorts of things. In that you may have a rub there, but it's not necessarily impeding the recovery of the resource.
Mr. Pierce.
Thank you. This is Perry Pierce. I need to go all the way back to the beginning of this one, Jeff, and tell me how this differs from the current state. What does this recommendation change?
What this recommendation would do is it would put within state regulations a recognition of local authority. Right now, the state regulations, I think, mention local authority twice. One in the point where it talks about the state permits binding as against an operationally conflicting local, and that's about it. What this is it's advancing the state-local relationship by having the state recognize that when it comes to land use and surface issues, a local regulation may require new or additional mitigation techniques, provided it doesn't result in a preemption or an operational conflict.
Thank you.
And
You have a follow-on? Mhm.
Thank you. I understand that to be the current situation. I mean, I understand that the words local control do not appear, but in the absence of operational conflict, isn't that precisely what local authorities currently have the right to do?
Yes. What this is doing is it's explaining to operators that where a local has gone further than the state and say a visual piece or a noise piece, that ought to be considered valid by the state, as opposed to an operator running to the state and saying, I've got this visual mitigation thing that I really don't like. Will you tell the local government to remove it? Because that's some of the things that can happen under the current protocol. And what this is trying to do is to harmonize that local land use and surface, not technical, not downhole, just I'm sticking with the current authority, and just provide that any use of it by the local government that is perhaps more stringent, ask for more things, as long as it's not impeding recovery of the resource or otherwise an operational conflict, should be considered valid.
I think I understand. Thank you.
Dan Kelly, clarifying questions for Mr. Robbins?
Thank you. Mr. Robbins, and again, I struggle with some of the wording, but just with my lack of knowledge of legal issues, but and the way I read this is to amend the OGCC rules, and I'm questioning, does the OGCC have the statutory authority to do this, do you think?
I believe they do. We might ask the director that question, but I didn't craft this in a manner to try to create something that was beyond the power of the commission.
Okay, that's appreciate that. And then if there is conflict, the resolution to that conflict is an appeals process to the courts?
Currently, that is the case. I think there are several good proposals on the table to try to have some alternative to having to just go to court. But currently, the status is that if the state issues permit X and the local issues permit Y and they're in conflict, and the operator would need to have a court determine whether the local regulation is invalid under operational conflict.
Okay, thank you.
Okay, I need to move us on. Mr. Robbins, you still hold the floor with recommendation number 3.
Christine, I had a follow-up question.
Yes.
Mr. Robbins, just a quick clarifying question. Are you aware, is there any express prohibition that would prevent an operator from agreeing to something with a community that was beyond state standards?
No, there's no express prohibition for an operator in a local community to use the local community's contract powers to enter into agreements that go beyond the state. Some operators have done that. The problem, in my opinion, with that process is that oftentimes operators are not willing to go far enough because the leverage that local communities have is not great enough to require the more stringent sort of approach. I think that the issue that we're seeing in Erie right now, where they entered into an MOU that now their elected officials do not feel it to be sufficient enough, is indicative of that sort of process. But there is no prohibition.
Thank you.
And Kim Pepler, if you have a quick clarifying question.
Yeah, we're going to be talking a lot about local control today, obviously. And I guess I'd like a definition when you talk local control. Are you talking about county control? Are you talking about city having control? My concern is pretty simple. I have property that's not annexed, that's adjacent to the city. Is small town Meade, Colorado going to be able to jump across the road and tell me what we're going to do on our side of the fence?
The answer to that, Kent, is no. When we're talking about local authority, we are talking about county, town or municipality, and then city and county. There's at least one of those in the state. But any one of those is not able to jump outside of their jurisdiction and require something to be done. So in your hypothetical, the town would not be able to impose standards on your property that's in the unincorporated county.
But the county would be.
The county would be. Mm-hmm.
Okay, Mr. Robbins, I think we finished now with your proposal number 2. We can move to number 3.
Okay, this one is fairly straightforward. It would have the General Assembly acknowledge local authority in terms of zoning and land use and regulation. This one goes further than the last one in terms of establishing legislative intent that local zoning is valid over the oil and gas industry. So I have, I think, 5 recommendations. They're on a sort of a sliding scale, some that are more likely acceptable to many of us and some that are less likely to be acceptable to some. This would be on this part of the scale, just saying, but I was asked to give ideas.
Appreciate the candor. Clarifying questions for Mr. Robbins on this proposal.
I don't know, right, left, middle?
Mr. Pierce?
Thank you, Perry Pearson. Jeff, the way I read your italicized suggestion at the bottom of this recommendation, I'm concerned that the modifier in the first sentence doesn't appear in the second, and that's of concern to me. The as provided by law, and then I don't know what the second sentence does, frankly, but since it's there without the restriction, it causes me concern.
I anticipated your concern on this recommendation.
And your response to that anticipated concern is?
I was not trying to be tricky, Perry. I wasn't. And, you know, if this proposal gets to a point where 2/3 of us are interested in advancing it, I will certainly look toward friendly amendments to make it so that it's clear.
Thank you. Thank you.
All right, thank you. Mr. Robbins, you have another one. I am aware, Russ George, I think you have to step out at 11:30, so we might move you up in line. If you're comfortable going, is that all right with you? Are you comfortable going now? And we'll go ahead and get to yours. I believe it's number 7, and I believe you're stepping out for about half an hour. Is that right? Okay. Let's go to number 7 with Russ George.
Thank you very much for that courtesy. I wouldn't normally do this, except the conference call is with the people who've lately been signing my paycheck, even though I haven't been there very much. And, you know, that maybe, the wisdom of that maybe speaks for itself. So, okay, so number 7. The goal here is to listen to what folks have been saying, that it isn't always clear that the relationship between the state processes and the local government processes help each other. So this is an attempt to set in synchrony the local government processes with, as they exist today, with the state permitting processes as they exist today. So what the essence of it is this, that the state permitting process waits until the local land use process has a chance to conduct its process. Now, what does wait mean? How long? Time frames need to be developed. I didn't try to put them in here because everything we do here is conceptual, and any change that would implement this or other of our recommendations will go through public processes, and those times will be developed by the stakeholders, and we would expect that they would be somewhat in sync with the concept. So I've not put the timelines in, but there need to be time constraints on the relationship between these two processes. Simply said, one, the local government can't just stall, okay? So there have to be timelines, but state process gets really the first chance to take a look at this. Then the second essence of this is to incentivize, by this change in process, those efforts that have been successful. So we're talking about master planning, comprehensive planning of any kind, and MOUs. So what we're saying is, if the local government process has in place master planning that actually governs the application by the drilling operator to come before the local government, and they reach agreement based upon the terms, conditions of that master plan, that moves, once that agreement occurs, that permit moves to the state, and it is expedited according to the terms agreed upon by the local government and the operator to the extent not prohibited by state law. So the incentive for both is that local government is advancing its requirements. The operator, by meeting those requirements, can move his state permit approval to the head of the line. So that's true for MOUs as well, to incentivize that. Any successful effort at the local level that reaches conclusion that is acceptable to both local government and the operator may then move forward to the state permit process, and the state, to the extent it can within law, will approve those conditions as part of the permit. Now, that's the positive side. The negative side is, if for any reason there's been no master plan, no comprehensive plan, no MOU, and they can't reach agreement on application of local government land use conditions, notice of that impasse can be given by the operator to the state, and then the state moves forward with its existing permit processes irrespective of whatever the impasse was, which is essentially where the state can be today. That's it.
Thank you. I had John Golden Dubois, followed by Gwen Lackald, and then Bruce Rao.
Thank you. This is John Golden Dubois. I have a clarifying question about intent. It seems to me as I read this that in the event that there is an impasse, that the issue would then be resolved by the COGCC, and that seems to preclude a solution that might involve going to court. And so my question is, as you would have today, my question is that the intent is to remove that step as an option for a local community, or is it simply to provide this additional step, but then a local government would still have that option to challenge either the directive of the COGCC or the agreement with the operator?
The intention is not to change any party's opportunity to seek redress in district court.
I had Bruce, yours is Dan, Bruce Rao, Matt Sura, Bernie Busher, and then Becky Corliss.
So a question specific to zoning. You mentioned zoning in sort of the first line of your description. And as I read through your proposal, the proposal talks a lot about MOUs and CDPs and master planning processes. And I just want to make sure I'm clear on where you are on the issue of zoning versus these other processes, because let me just stop there because I don't want to give too much description. I just want to understand what your thought is about the specifics of a zoning action versus these other processes you've described that a city may enter into.
The use of the term zoning ordinance belies my age and when I was in law school. It's meant to be the broadest terms that we use in municipal or county government. They're all different. Some still call them zoning ordinances. Some call them land use planning processes. I meant to be inclusive of those local government processes that are impacting the ability of an oil and gas operator to go forward in the jurisdiction with its activities.
Thank you, Matt Sura, and we only have a couple of minutes left.
Great. Russell, I thought that this was great. I was checking everything is good, good, good until I got to E, and that's where the rubber hits the road. And it says that the Oil and Gas Conservation Commission will be able to decide on applications where the requirements of the granting approval are prohibited by state law or are unreasonable. And then it goes on to say that the permit application will be granted so long as the operator has participated in local government land use processes in good faith. And so there's some loaded statements in there, and I'm just wondering who's ultimately deciding those issues. If it's prohibited by state law or unreasonable, or if the operator has negotiated or has participated in good faith.
Okay, so I think I wanted to clarify one point. I think you said is that the permit, if there's an impasse reached at the local government discussion with the operator, then the permit would go, state permit would go forward.
That's the way that I read it.
Okay, the process will go forward. There's nothing there that says the permit will be granted.
No,
So I don't
of
want to
course.
be unclear about that. So
Understood.
what you're asking me is who gets to decide about unreasonable and good faith? Same places we always do it. In the rulemaking process that would implement this, the stakeholders would reach agreement and the rulemaker would define the criteria for reasonable, unreasonable, or good faith. And they're already in the law in many places, in the oil and gas law in many places. I wouldn't change those commonly accepted definitions.
Thank you. We're really out of time. Bernie Busher and Becky Corliss, if you have just a quick question.
I'll be quick.
Mr. George.
Russ, I like a lot of this. I read it as applying to all drilling and to all production. There are no limits there. And to the entire state, not limited to urban mitigation zones. The place that I'm a little fuzzy on is in the phrase, the state shall proceed to process the permit applications. And I understand your clarification on that they'll process it, but I think it needs to be clear that you're not limiting their authority to make the decisions they would otherwise have made.
I would accept that as a correct clarifying feature.
Ms. Corliss.
Two very quick yes, no.
Oh, it always makes me nervous when the judge does that.
Is this intended to apply to siting only, Russ?
No.
Second, would it be susceptible to dovetailing into a dispute resolution process?
Sure.
All right, very good. Thank you. And we will go back to Jeff Robbins. I believe we left off with number 4.
Okay, so Jeff Robbins again. This gets to Ms. Corliss's question earlier about preemption, and this is a little legalistic, and I apologize for that up front. But what this attempts to do is to adjust and improve the current operational conflict standard that governs the relationship between state and local regulation. And the current standard, as I said earlier in response to Commissioner Pierce, is that where a local government's application of a regulation materially impedes or destroys the state's interest, it can be deemed invalid. The state's interest has been interpreted by the court to mean the goals of the State Act, the goal of fostering the development of the resource, the goal of making sure there's not waste, the goal of planning, et cetera. So all of those goals can be tools within which a local government regulation can be invalidated. And some of those goals are pretty large. And so local regulations can be invalidated broadly under the current standard. What this standard would do would be to adjust the preemption standard in a manner that would facilitate local government regulatory processes, and that those would be deemed valid by a court unless such process materially impeded or destroyed ultimate recovery of the mineral resource. So this would allow a local regulation to go further than just materially impeding the goal of fostering development or the goal of the other goals within the State Act. And it really brings the local regulation's validity based upon the concept that the local government can't use it to stop development of the resource. So I'll stop there.
Becky, I think your card was just lingering, so I have Bernie Busher.
This is Bernie. Jeff, what you said is a little different than the wording here, and I want to just make sure that I understand your intent. The language that you've drafted says may be preempted, but I think what you're saying is that a local regulation is not preempted unless.
I would be fine with
I mean,
that approach
and
too.
I see those as different.
Right.
Maybe it's kind of open and, well, maybe. So I just wanted to understand what you're driving at.
And that might be a good point to discuss as we get into discussing this. I wasn't attempting to create when you apply the standard by the court, it is subjective in terms of whether the resource is materially, ultimate recovery is materially impeded. But your rephrasing it, I think, is probably valid.
Okay.
Brad Holly?
Hey, Jeff, just a clarification. Is this issue currently, or is it in front of the Court of Appeals?
I don't think it is. And the reason for that, Brad, is that the preemption standard that has been developed by the courts is the court's best guess at what the Colorado legislature meant when it created two buckets of authority, a bucket for locals and a bucket for state. Because what they're trying to say is, what did the legislature intend? And what this would do is provide intent of the legislature that local regulations should be valid, provided they're not impeding recovery of the resource. And so I don't think this is before the court, because we've not had the Colorado legislature provide additional intent here recently for that to make it to the courts. There's a lot of oil and gas lawyers in this room who may disagree, and I'd be happy to be corrected.
Thank you. I had Bruce Rao and then Perry Pierce.
Jeff, could you define for me what you mean by ultimate recovery? I think that's a little bit unclear. I mean, is ultimate recovery the ability to recover it someday based on some technology? Or is it the ability to recover all of it under current technology? Just kind of give me where you think that definition falls so I understand your proposal.
I think that point should have all the bright minds in this room, look at that if this proposal moves forward. My concept here is that you ultimately are able to extract this resource, but that would not mean that you are entitled to extract every bit of it all of a sudden today or in the next year. That a local government could, under this preemption standard, enact regulations that are not ensuring that everything has gotten out immediately, but that as long as they're not precluding development of all of that resource at some point, they should be considered valid.
Okay. Perry Pierce.
Thank you. Perry Pierce. Jeff, I'm not sure I have a question, but I will express a concern that you may have anticipated. And that is that I find material impedes to be so unspecific and unclear that I think it actually takes a step back from the current legal analysis. I mean, I do not know, and I don't think the 21 people sitting around this table could reach agreement on what material impedes is. And therefore, I am concerned that what is being recommended will just not be clear to anybody.
And this probably falls into the discussion arena, but we should discuss substituting that definition, which just comes from the courts, and making a better one and say where it does not allow ultimate recovery. I mean, you could do something like that. I just was using Bowen Edwards and the language the court had come up with because they're the Supreme Court and they're smart.
Not as far as it used to be.
So noted. John Golden Dubois, and then we'll move to the next recommendation.
So Jeff, if I understand this might allow a local government to take measures that they feel would help to protect their communities on some of these health and safety issues that we've discussed, some of the nuisance issues that we discussed, and may also allow them to do something like phasing in of development so that they could kind of control in some way in concert with the industry where development's going to happen at a particular point in time. Is that correct?
That is correct. And again, it's not telling them, go do it in X fashion or go do it in Y fashion. Let the local governments figure out what's appropriate for their community. This allows for that smart approach to governance, yes.
So they couldn't prohibit, but they would be allowed to.
Could not prohibit,
establish
exactly.
conditions.
Okay, very good. If we're ready, we can move on to the next recommendation put forward by Matt Sura, number 5.
Thank you. And I believe that what this does is really tier well with what Russell George has put forward. Russell George puts forward an excellent list of all the ways that local governments can authorize oil and gas development within their jurisdiction. And as I mentioned in my question in the preface to my question to Russell George, the only part that I kind of disagreed with his proposal is what happens if the local government doesn't agree. And what we've provided here, what I've tried to provide here is a mediation panel that I didn't describe. It's described in other proposals, I understand, but it would really state that the Oil and Gas Conservation Commission in its Form 2A and its location assessment has a lot of information. It's a 4 to 8 page document. And they ask where it's located. They ask if it's close to a stream, if it's close to a home. They ask everything except, does the local government like that location? It's not anywhere on that form. Local governments have land use authority. Supreme Court has stated this numerous times. They've had land use authority far longer. In fact, almost 70 years prior to the Colorado Oil and Gas Conservation Commission being in existence. So there's they're not foreign to land use authority. They apply it to absolutely every industry. Where they get in trouble applying their land use authority is in the oil and gas industry in this one instance. All this is saying is that, yes, they have land use authority. Yes, the Colorado Oil and Gas Conservation Commission is interested in knowing whether or not there's an agreement with the local jurisdiction. And if there's not an agreement, there's a way to try to resolve those differences. If those differences can't be resolved by a mediation panel, then they have the option to go to court.
Questions for Mr. Sura? Becky Corliss.
So Matt, as Jeff outlined it, we're in a continuum here of where the interests are harmonized. As I understand your proposal, or as you pointed out in Russ's proposal, where the rubber meets the road here is that your proposal would require local government approval, right? Before a permit could issue, local government would have to approve it.
That's correct.
Further questions? Okay. I'm going to move us to proposal number 6. John Fitzgerald. Or Jim, sorry. I know a John.
The proposal that I have is something where, after talking with a lot of people who have been affected by drilling or involved in the drilling, and people who were involved in the initiative for ballot process, I was looking for a way to describe a solution that would be clear, that people would understand, and that people would support as something that was fair and that made a change. I had a lot of these conversations, and I found in the process something that I think people know is that there's a lot of cynicism, there's a lot of anger, there's a lot of frustration amongst certain people, and that it's unhealthy, and that if we are going to get public support for what we do, and if we don't get public support, what we do is going to go nowhere in terms of finding a solution. And so I was trying to find wording and something that would be better for industry, which would be better for the state, and which would be better for ordinary people who are affected by drilling. I believe that drilling is a big deal, has huge impacts on local residents, things that we don't weigh or talk about much, but we know that are there. Husbands and wives who don't talk to each other for months because this threat of a gas well coming in on them has so disturbed them. I think when we talk about the production, you include the value of a family. And so the other proposals, which would give some specific power to local government, are very good, and I support those things. But if I were looking for something that's very straightforward, to say, this is a big deal, and these arguments ought to take place not only at a state level, but they ought to take place at a county level, where people go to hearings, go to meetings, argue, state their thing, where you have, because the problems are so subtle, every placement of a well is different. It's hard to talk about it in terms of feet when you think of the attachment people have to certain pieces of land and certain uses of that land. And if that is argued or discussed face-to-face at a local level, as well as at a state level, we're going to have a much healthier environment. And so, in short, all this proposal tries to say is something that I think would be very understandable, and on my totally non-statistical, non-sophisticated sampling of talking to people, I think would get a lot of support. And people would say, this commission did something. If we simply have a process where local government has to sign off on it and state has to sign off on it, and it won't go forward. And and I agree with Bernie, I don't care about the number of days particularly, I mean with Russell George, whether it's 30 days, but I put in there 30 days discussion and then 30 days afterwards. Then it goes to the courts to decide. I don't think this would happen very often, by the way. I think a lot of what we're discussing happens rarely, but when it happens, it's a huge deal. So that's my proposal. No permit would go forward unless it has a sign off of the state and of the county or the municipality.
Brad Hawley.
Yes, Jim, thanks for your proposal. My question is there anything in Mr. Sura's number 5 that's not covered in 6? It sounded like the descriptions are very similar. So my question to the group is 5 and 6 actually the same?
Yes, it's very similar and it certainly has that, and I would support Mr. Sura's. The only thing I think that's a little different is that I think mine's a little clearer, and I'm focusing only on this issue of the sign off on check the box, and that makes it somewhat understandable.
Thank you, Will Tour, Sarah, and then Sarah Berwinski.
Just a follow-up to that last question. It seems to me that the one substantive difference is that Matt's proposal explicitly has the mediation step.
Yeah.
So I don't, explicitly has the mediation step that is not contained in this proposal. So they're similar, but I think that there is one substantive difference.
Very good. Sarah Berwinski.
I was going to observe the same thing and wondered if you also would be open to a dispute mediation step prior to court. Well, I know some of the things we talked about with Russ and some of the things that Becky had on the table was like a land dispute mediation to have an alternative to going to court. It didn't preclude going to court, but there was that step. So I was just wondering about if that could fit into your scheme.
One of the things that's part of this is the whole issue of takings, the whole issue of how they mediate, how that is going to happen much more at a county level. If a county wants to go further than the state and they want to take the risk of takings, or if they want to have a strict mediation process or not, I would like as much as possible for those decisions to be left at the county level. They have attorneys, a lot of them are very sophisticated, and they can take their own risks on something like that.
With that, we'll move on to recommendation number 8, Bruce Rao.
Thank you. This is Bruce Rao. So I took a little bit different approach to this challenging question, and it was really driven by my concern as I listened to the widely varying opinions of all the many attorneys involved in this process about exactly what control local jurisdictions have and what they do not have. And took the next step to sort of say, well, let's propose that we would change it either to one side or to the other. And I was convinced, although the voting doesn't necessarily show this, I would have gotten my head cut off for having proposed a change where it was so uncertain as to what the current condition was. I think the reality is that the actual current condition is being tested in court and will continue to be tested in court. And so my approach was different. My approach was to try and find a sort of productive way that local jurisdictions and the state could work together towards common solutions to the extent that they could outside of the court, although I'm not proposing limiting any entities' recourse to the court under the current situation. But it was really around this concept of, can you provide a safe harbor mechanism where state and local can work together effectively and efficiently and get to sort of the best outcome that we can reasonably do. And so in my proposal, it had several parts. The first part was to establish some specific authority to the state to regulate the siting of oil and gas activities. And that was something we heard from Director Lepore at the last meeting. He felt he was a little bit hampered to do, and in reading of the rules, I think today that is true. Now, whether that requires statutory change or rulemaking, I'm not sure. My assumption is statutory. But I think that to the extent that there's a known problem out there or a problem that the director can see coming, I'd like him to have the tools and resources to try and correct that situation along the way. I think that same set of resources ought to be available to the local government. So what I provided was that the state would, upon request by the local jurisdiction, delegate that siting and surface use authority to the local jurisdiction. Again, this is a new specific authority that they have that they can delegate, and I would not propose to change any of the existing authorities that the local jurisdiction might have in that process. So state can delegate it. State delegates it with a set of rules that it's living by. So both the state in operating in this fashion or the local jurisdiction would have to follow the same set of criteria for evaluating surface locations. And I provided a set of 4 criteria. I think we could spend a lot of time talking about exactly which are the right criteria and would be happy to do that. But I think just suffice it to say that those criteria are designed to protect the mineral owner, to benefit the surface owners or protect the surface owners, and to benefit or protect the residents and the community surrounding the operation. And it is a difficult balancing act that local jurisdiction would have to do or that the state would have to do. But not surprisingly, almost every annexation, zoning, master plan, or development plan application that a city reviews has that same process where they have to balance multiple and, in some cases, conflicting interests. And so I think that this process is something that local governments are very familiar with. So step 1, give the authority to the state. Step 2, delegate that authority when it's requested with the same set of rules that the state would have to utilize for that set of authority. And then I think the next step, and this actually sort of gathers in a lot of proposals that others have made on the task force around what are the tools that might be needed in order to accomplish this process. And I list a long list of them. Some of those may fall in and some of those may fall out, but my idea is particularly this, that if a local jurisdiction or if the state identifies that site B is better than site A for some specific public purpose, I want to be certain that there's a mechanism for achieving that outcome. I don't want to put industry in a position where they're obligated to go to a certain location but have no mechanism to make sure that they can do that. So that cuts a little bit against me as a surface owner, because ultimately what I'm doing is I'm giving someone else authority over what's going on my surface outside of my direct negotiation, and that's challenging. And I think that some of the other proposals that the group has put out, in particular, some that Becky put out on surface owner damages, could help resolve that. But I think it's important that if a location is better for some specific public purpose in the perspective of the local government, I want to make sure that they can achieve that and that the operator can achieve it effectively. So we've granted that authority to the local jurisdiction. We've provided some tools to try and get to the best outcome that you could. And I think in the end, I believe, as Director Lepore indicated, that ultimately the decision-making has to come back to the state as the final issuing authority on drilling permits. But to the extent that the state wishes to override the recommendation or the decision, I won't say recommendation, the decision that the local jurisdiction has made, I think that they need to also be controlled in such a fashion as to protect that local government decision and the purposes by which it was made, and really ensure that it's a real decision. And so when the state steps in, they've got to have really good justification for doing that. And so I have provided some set of criteria to protect that local government decision. Ultimately, I think any and all of these decisions have the potential to be appealed to the courts, but I believe that this provides a safe harbor where locals and the state can work together without being in the courts in the most productive way that they can, and with a set of guardrails around all of their actions that protect each and every one of the interested parties in the process. I don't want to pretend that any of that would be simple or easy, but I think that it is a workable process that hopefully keeps all of our jurisdictions from small towns in Weld County or in Boulder County or anywhere else from spending all of their budgets that they'd like to spend on other things in court proceedings, because I think it provides that mechanism to accomplish that. So that's the proposal, and I'm open questions.
Okay, I had Bernie Busher, followed by Steve Marino, and then John Golden Dubois.
Bruce, you know, I want to commend you. This is the most original, and I know you've spent an extraordinary amount of time. I like a lot of this. In some ways, I think what you're doing, though, is replacing a devil that everybody knows with a new series of devils, and that may be good. We may be there. I like an awful lot of this. Bruce, do you intend that existing surface use agreements and MOUs are grandfathered? Are they, you mentioned shall not diminish valid existing rights. I'm not sure what you mean by that phrase.
Sure. So I'll be a little bit cautious there. I will say that in almost any circumstance where you're instituting a new rule that has a substantial impact on agreements and decisions that have been made in the past, I think it's really important that you consider the value of those and evaluate whether or not you're overturning them. And I think, in fact, and the attorneys on the task force could tell me their thoughts on this, there are certain circumstances where those must be protected, right? So it's a difficult question. If you protect everything, you can't ever change anything, right? If you protect nothing, then businesses like mine and like the oil and gas industries and even the MOUs that cities may have put in place would be subject to any and all future rulemaking or lawmaking. So I think that it is quite critical that businesses are able to make decisions and move forward with them in an efficient manner. I think that's important in all of our businesses. But I think there are also circumstances where that can't always be the case. And I think that the tipping point for me there is if a true health and safety issue can be identified that justifies impacting those sorts of decisions.
Thank you. Steve Marino.
It's Bruce, under number 3, when I'm reading through this here, you're saying require that the following the legislative established criteria be reasonably balanced in the regulation of location and/or establishment of comprehensive drilling and location plans. Can you elaborate a little bit more? I mean, we're talking about setbacks when I'm reading into that. Is that incorrect or is that correct?
So it wouldn't surprise anyone on this task force that I didn't use the word setback in that discussion, and very intentionally so. I think a setback is a very crude and ineffective tool, particularly beyond the current setbacks that we have in regulating this. In fact, I spent quite a bit of time sort of looking at and studying the proposal or the outcomes of what went on in Greeley that Sarah and her group brought to us at the last task force meeting, and identified that in fact some of the proposed setbacks would have precluded that solution, which ultimately was a better solution than the original proposal. And so in my mind, we're trying to balance all of the competing interests rather than identifying a specific standard that must in all cases be met, that in certain circumstances would actually encourage a worse answer, right? So any discussion of location will come to some discussion around distances, but I am not, in this circumstance, in support of the idea of proposing or recommending to any jurisdiction that they apply new generalized setbacks that apply everywhere.
Thank you. I had Perry Pierce, and then we'll move to the last recommendation.
Thank you. This is Perry Pierce. Bruce, I wonder if we do not accomplish most of our goal of recommending perhaps a change in emphasis at the COGCC by moving forward with your sections 1 and 6. The way I read this, section 1 essentially says we have to increase the recognition of the purpose of reducing impacts and conflicts, and that we are recommending that the COGCC take steps that are available to it to accomplish that. And then section 6 has the tools which we suggest should be, if they are not now, available to the COGCC. There are some specificity in the other sections that I think are not necessary. So I'd float that out just for you to give some thought to, if you would.
Sure. So with respect to paragraph 1, I think that whether a local government wants to use that authority or not, I think the state should have that authority. And I think that it will improve the operation at the state level and their ability to avoid conflicts where they can be avoided. Having said that, I also think that paragraph 3 is quite important as applied to paragraph 1. And that is there need to be some parameters around which any organization would use that rather powerful tool. And so whether A, B, C, and D are precisely those criteria, I think criteria need to be established. As to excluding local government from that process, my view is that, having sort of listened to all the testimony we've had and all the discussions that our task force have had, I think that it is important that we give local jurisdictions a place where they can operate effectively, and I don't know if safely is the right word, but in a way that sort of protects their ability to continue operating, but also at the same time protects the industry and the surface owners and everyone else. So I see this as a way to get at that in a, again, sort of the safe harbor concept, where you can operate inside these boundaries and not feel a lot of risk. And I think if we fail to give some additional clarity and or specific authority at the local level, I think it's going to be very challenging for us to achieve the goal that the governor has set out for us. If I'm wrong about that, I'm happy to get to a different solution. But my solution was intended to come straight to the middle, in between what I see as very polarized proposals from the opposite sides.
Thank you. And again, we'll have time for full discussion here briefly. If we can move to recommendation number 12, Becky Corliss.
Well, actually, a friendly amendment. I think that 9 belongs in this conversation. Am I wrong?
9 got over 50% green, so we'll talk about it tomorrow. If you want to
get
just
it.
briefly-
Okay.
and 10 and 11 got combined, and they also moved into the green category, so they will be tomorrow, and they address pooling, which is one of the.
Okay, so 12, broadly stated, is a suggestion that we consider a dispute resolution mechanism for conflicts between what local government would request and what the state would otherwise require. My suggestion is not rooted in the details, but rather a notion that there would be an independent body to which these disputes would go, probably on a non-binding basis. I actually think non-binding arbitration is probably more effective than mediation, but that too would be up for discussion. The composition of the body that I've set out in this recommendation would be 2 members from industry, 2 members from local government, and a neutral. But it could be just 3 neutrals who would be appointed or decided upon in some different context. This arises out of 3 concerns. 1, efficiency. If we are allowing for resolution of conflicts that are more robust and that require both more fact-finding and allocation of decision-making power, that's a lot to ask of the COGCC on top of everything else they do. In addition to which, I'm not sure that they are positioned right to do that dispute resolution. On the other hand, it has to be efficient, effective, not expensive for the parties to pursue, or it will make things more difficult, not less difficult. Last point, it is not my intent in any way to preclude the parties from going to court or to interfere with that process, merely to provide something that's more efficient and quicker, from which a resolution may flow.
Thank you. Bernie Busher? No Bernie Busher. Any clarifying questions? Dan Kelly?
Yeah, Dan Kelly, I'd just like to ask again, you said it, I want to land on a little bit. You're not set on having 2 local officials or 2 officials from the local municipality firmly. You said you might agree to like 3 neutral parties in this particular case if you ran down this.
Yes.
Okay, thank you.
Matt Sura?
This is a question for you, Becky, or anyone else that thinks they have an answer for it. Does this have to happen through legislation? The reason I ask is that I know that if Colorado and Gas Conservation Commission were to try to delegate its authority in almost any way, it would be precluded from doing that from statute. But if it's just a recommending body or just a mediation or non-binding arbitration, I'm not sure that it would fall into that category and maybe could be done administratively.
I think, Matt, it probably could be done administratively if it's not a precondition, if it's merely an option that would be available to the parties.
Okay. All right, that concludes our initial lightning round discussion of the first set of recommendations. What I'd suggest is that we go ahead and do a working lunch, given how tight our time frame is this afternoon. So if you all want to grab lunch, we'll give about 15 minutes to come back to your seat. And then we have an hour of discussion where you can weigh in with ideas, feedback, opinions, suggestions for consolidation or other recommendations to the authors, and we'll reconvene then.
With